3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time we walked through the Palm Beach investigation and tested what the records could actually prove without speculation. Today we are examining the prosecution begins and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is Palm Beach State Attorney Barry Krischer's decision to present only a single charge of solicitation to the grand jury in 2006, despite the police department identifying over 40 victims.
And right there, we have to establish the protocol for today. This is a forensic audit. It's not about narrative, it's about the paper trail. We're looking at a very specific window of time from when the police investigation wraps up in early 2006 to the moment the federal plea deal is signed in 2008.
Right. Our entire mission here is to separate the immense noise of the headlines from the actual signal in the evidence, the court documents, the police letters, the non-prosecution agreement itself.
The signal is what's on paper, signed, dated.
And the objective is to answer one question, really. It's the one that underpins everything else. How does a case with, and this is the police's own term, probable cause affidavits for multiple felonies against multiple victims end up as a single solicitation charge with sweeping federal immunity?
To get to that answer, you have to start with the first documented point of friction.
Yeah.
And we're not speculating about this friction. We have it. It's written down. It's on official letterhead.
So evidence block 1, the anchor document for this whole period, it's a letter dated May 1st, 2006.
A physical letter, not an email, not a memo.
From Michael S. Ryder, who was the police chief in Palm Beach, and it's addressed directly to the state attorney, Barry E. Krischer. I'm looking at the scan of it now. It's on Palm Beach Police Department stationery. This is as official as it gets.
This document is absolutely vital. You have to understand, this sets the baseline reality before the federal government is even in the picture. This is a local problem. A local police chief writing to a local state attorney to create a permanent, undeniable record.
Why is that so important? I mean, creating a record.
In the world of law enforcement bureaucracy, you don't send a letter like this unless you're afraid the official story is about to be changed. He is, in effect, planting a flag in the ground. He's saying, on this date, this is what my department did, and this is what your department did not do. It's a defensive move.
Okay, so what does the letter actually say? Ryder writes that he is submitting probable cause affidavits for Jeffrey Epstein, for Sarah Kellen, and for Haley Robson. He calls it the Palm Beach Police Department's presentation for prosecution.
Let's pause on that phrase for a second. Probable cause. We hear it all the time on crime shows, but in a legal document like this, what does it actually signify?
It's the legal standard, right?
It's the finish line for the police. It means the investigators have done their work, they've conducted the interviews, they've gathered the evidence, they've found corroboration, they believe they have enough to make an arrest and secure a conviction. When a police chief signs his name to a letter that says, "I am submitting probable cause affidavits," he is formally declaring, "Our job is done. Here is the case, ready to go. The ball is now in your court."
But then, right after that procedural language, the tone of the letter, it changes. It becomes sharp. Ryder writes, quote, "I must renew my prior observation to you that I continue to find your office's treatment of these cases highly unusual."
Highly unusual. Let's just sit with that for a moment. In the very careful diplomatic language of legal and police correspondence, that phrase is a cannon shot.
It's not subtle.
It is the opposite of subtle.
Yeah.
You do not put in writing that the state attorney's conduct is highly unusual unless you are officially documenting a profound failure of the process. It is the most polite way imaginable of saying you are obstructing this investigation.
And he provides specifics to back it up. He doesn't just make the accusation. He writes, "It is regrettable that I am forced to communicate in this manner, but my most recent telephone calls to you and those of the lead detective to your assigned attorneys have been unanswered and messages remain unreturned."
And there it is, the first major documented red flag in this entire audit. Just think about the operational reality for a second. This isn't some minor shoplifting case. You have a high-profile suspect. You have allegations of a widespread sexual abuse network involving dozens of minors, and the chief of police cannot get the state attorney on the phone.
It's not just a missed call, it's a pattern. Unanswered and unreturned. plural.
That silence is an action. It's not passive. An institutional wall is being built right there in that sentence between the people who investigated the crime and the people whose job it is to prosecute it. Barry Krischer isn't just busy. He is making himself unavailable.
The letter builds to a climax, and it's a request that,
Cool.
well, it's breathtaking, frankly. Ryder urges Krischer to, quote, consider if good and sufficient reason exists to require your disqualification.
He's asking him to recuse himself.
The chief of police is telling the county's top prosecutor to get off the case.
It's almost unheard of. This is the proof. As early as May 1st, 2006, months before the feds are involved, years before the public understands the scope of this, the local police force had already formally, on the record, documented a complete and total lack of confidence in the state attorney's ability to be objective.
They suspected something was wrong.
They suspected, on paper, that the fix was in. They might not have known why it was in, but they knew the behavior of the prosecutor's office was not the behavior of an office seeking justice.
Okay, so that letter lands in May. Krischer is now on notice. Let's move the timeline forward 2 months. It's now July of 2006. After the ignored calls, after this bombshell letter, State Attorney Barry Krischer finally takes action. He presents the case to a grand jury.
And this is where we find what we have to call the indictment discrepancy. The police files, as you said at the top, identified over 40 victories. The probable cause affidavits that Ryder sent over described multiple felonies: rape, sexual battery on a minor.
Serious life-altering felonies.
Correct. But when the indictment is handed down by the grand jury in July 2006, what does it charge?
1 count. A single count of solicitation for prostitution.
And just as important is what's not in the charge. The document itself notes there is no reference to minors in the indictment.
That feels, how is that even possible? I've gone through the police reports. The case was about minors, almost exclusively. How do you construct an indictment based on those files and leave out the central fact of the crime?
You do it by deliberately sanitizing the record, by framing the charge as solicitation of prostitution without the minor qualifier. The state attorney's office performed a kind of legal alchemy. He transformed child sexual abuse into adult vice.
He turned a predator into a John.
Precisely. And that changes everything. The entire legal classification of the crime is altered. If you're charged with soliciting an adult, it's a misdemeanor. It's a nuisance. If you're charged with soliciting a minor, that's a serious sex offense. It means a sex offender registry, mandatory prison time. There are two completely different universes of crime.
And we have another piece of correspondence from Chief Ryder that shows his reaction. It's another letter, this one dated July 24th, 2006. It's addressed to the father of one of the victims.
And this letter is, for all intents and purposes, the police department washing its hands of the state attorney's decision. Ryder writes directly to this father and says, quote, I do not feel that justice has been sufficiently served.
Can you imagine getting that letter? The chief of police telling you, I'm sorry, the system failed.
It creates a documented split that we have to be absolutely clear about. The state-level case against Jeffrey Epstein did not fail because the police came up short. It did not fail for lack of evidence. The records prove the police believe they had more than enough probable cause for major felonies. The case failed because the state attorney made a choice to ignore that evidence and pursue a much narrower, much safer, much less serious charge.
So that takes us right into evidence block 2. We have to drill down on the why. We can't know what was in Barry Krischer's head, but we can audit the official justification. What reason did he give for gutting this case?
For that, we have to look at later documents. Specifically, the Department of Justice's Office of Professional Responsibility report, the OPR report, and archives from the Palm Beach Police Department. In depositions given later, Chief Ryder recounted exactly what Krischer told him in their few conversations.
And the official reason was?
The record states that Krischer's position was that he did not believe the victims were credible.
Not credible, the classic defense.
Yes. These girls are unreliable, they're troubled, they can't be trusted on the stand. That was the justification. But we have to audit that claim against the actions he took.
Okay. Right. If the victims are not credible at all, then why did he charge Epstein with solicitation?
Exactly. That is the core procedural contradiction. You can't have it both ways.
If the witnesses are lying, you have no crime. You have nothing. You can't bring any charge.
But if the witnesses are telling the truth, then they are minors, and the crime is a felony. There is no logical middle ground where a victim is credible enough for you to believe she was solicited for prostitution, but not credible enough for you to believe how old she is. Her age is a fact, not a judgment call.
The logic just doesn't hold up.
It collapses under the slightest scrutiny.
And the documents show Krischer proposed another course of action that... It's just bizarre. When I first read this, I thought it had to be a typo in the legal code.
He suggested that the Palm Beach Police Department should just issue Epstein a notice to appear.
Okay, for anyone listening who hasn't spent their life reading legal filings, let's break down what a notice to appear actually is.
It is the legal equivalent of getting a parking ticket. Literally. If you get caught with an open container on the beach, or you're cited for speeding, the officer hands you a piece of paper. You're not arrested. You're not put in handcuffs. You're not put in the back of a squad car. There's no booking, no fingerprints, no mugshot. You get a summons telling you to show up in court on a certain date to deal with a misdemeanor.
So, to be perfectly clear, the state attorney for Palm Beach County's initial recommendation for handling a serial child abuser with over 40 identified victims was to use the same procedure as a traffic violation.
That is what the record shows. And again, you have to ask why. Why would a prosecutor want to handle a case that way? It's not about efficiency.
It's about exposure.
It's about exposure. If you arrest Jeffrey Epstein on felony charges, it becomes a public record the moment he's booked. The media gets the police blotter. There's a mugshot released. It is an event. If you issue a notice to appear, it flies completely under the radar. It creates no immediate public record of an arrest. It sanitizes and minimizes the entire encounter.
But Ryder didn't go for it.
Ryder refused, and that's why we have these probable cause affidavits. Ryder forced the issue. He filed the felony paperwork with Krischer's office, which made it impossible for Krischer to just issue a ticket without creating a massive paper trail of his own negligence. Ryder was essentially saying, if you're going to let this man walk, you're going to have to do it in broad daylight. I will not help you do it quietly.
So when Ryder uses that phrase unusual course in his letter, looking at all of this, the stonewalling, the discrepancy between victims and charges, the traffic ticket suggestion unusual course, feels like the understatement of the century.
It establishes the fundamental truth of this phase. The prosecution begins with an immediate, documented, and successful attempt by the state attorney to kneecap the case. This wasn't an investigation that ran out of steam. This was an investigation that hit a wall intentionally built by the prosecutor.
And that wall is what leads directly to evidence block 3, the federal takeover. There's a common misconception, a popular narrative, that the FBI saw this case being mishandled and swooped in to save the day. The documents tell a very, very different story.
They do. The federal involvement was not a seizure. It was an invitation. Go back to that same letter from Chief Ryder on July 24, 2006.
The one to the victim's father. He writes, quote, "This matter has been referred to the Federal Bureau of Investigation to determine if violations of federal law have occurred."
The police chief made the call. He brought the FBI to the table because he believed the state attorney was actively sabotaging justice. The entire federal case only exists because the local police department lost all faith in its own local prosecutor. Ryder was, in effect, going over his head.
So the police bring in the FBI. They're hoping for a stronger hand. They're looking for federal charges. What would that be? Sex trafficking.
Sex trafficking across state lines. Transporting minors for immoral purposes. That's the Mann Act. Since Epstein was flying these victims between Florida, New York, New Mexico, the Virgin Islands, it looked like a clear-cut case for federal jurisdiction.
So the police were essentially shopping for a prosecutor. They had a case fully built, and they were trying to find a jurisdiction, any jurisdiction, that would actually take it to trial.
That's exactly what was happening. But instead of a federal trial, what we got was the non-prosecution agreement, the NPA, signed in September 2007, finalized in 2008.
I have the text of the NPA in front of me. It's pages of dense legalese, but some of these clauses are just extraordinary.
This document is the contract that officially ended the prosecution. And when you audit the text of this agreement, which, again, is available at epsteinfiles.fm, it is a historical anomaly. There are very few deals like this in the history of the Justice Department.
Let's start with the immunity clause. A typical plea deal is a trade. A defendant pleads guilty to a lesser charge, gets a lighter sentence.
And in exchange, the defendant cooperates. They tell the government everything they know about everyone else involved. That's the point of a plea deal. You give up the big fish to get leniency, but you help the government roll up the entire network.
But this deal, this clause, it does the exact opposite. The agreement says the United States will not prosecute Jeffrey Epstein. That's standard. But then it adds that it will not prosecute any potential co-conspirators.
Any potential co-conspirators.
That one word, potential. What does that mean in this context?
It's the poison pill. It means the immunity isn't just for the people they already knew about. It's a blanket shield that covers people they might discover in the future. It's a forward-looking immunity. Usually a plea deal is specific. You name the individuals who are covered. This deal does the reverse. It grants immunity to a nameless, faceless group of people who would have been named in a proper investigation.
So Sarah Kellen, who's named in the police files, she's covered. But so is anyone else who might have been involved, even if the FBI didn't have their name yet.
It effectively shut down the entire investigation into the network. By agreeing not to prosecute potential co-conspirators, the U.S. Attorney's Office for the Southern District of Florida agreed to stop looking. Why would you keep investigating if you've already promised not to bring charges against anyone you find? It didn't just give Epstein a light sentence, it gave his entire organization a get-out-of-jail-free card.
And on top of that, there was another procedural violation documented in the process of making this deal, the conflict with the Crime Victims' Rights Act, the CVRA.
Yes, the House Oversight Files and the filings from the Jane Doe versus U.S. lawsuit in 2008 lay this out clearly. The CVRA is a federal law that gives victims specific rights. The most important one is the right to confer with prosecutors and be heard before a plea deal is finalized.
But the records show the victims' attorneys were actively misled?
They were. The correspondence shows that while federal prosecutors were in rooms with Epstein's legal team hammering out the fine print of this secret deal, they were simultaneously telling the victims' lawyers that, quote, no decisions had been made.
They were lying to them.
They were lying to run out the clock. It was a deliberate institutional choice to conceal the existence of the deal from the people who had a legal right to object to it. The calculation was simple. If the victims find out, they'll go to a judge, and the deal could be scuttled. So they hid it until it was a done deal.
Which brings us to evidence block 4. These potential co-conspirators that the NPA protected. Who are we talking about? We have to look at what the authorities already had in their possession. The social network maps.
The Black Book and the Birthday Book, specifically.
It's important to make a distinction here. The media tends to use Little Black Book as a catch-all, but these are two separate artifacts.
A critical distinction. The Black Book is, for all intents and purposes, a Rolodex. A very extensive contact list. It has names, phone numbers, addresses. Having your name in that book proves you had contact or the potential for contact. It does not, in and of itself, prove you were a co-conspirator.
Right. Your electrician is in your contacts, but that doesn't make him an accomplice.
Exactly. The Birthday Book, however, is a different category of evidence. This was a commemorative book, a gift. Being included in that suggests a much closer social relationship. It's an inner circle.
And then you have the flight logs from his private jets.
The flight logs provide the opportunity piece of the classic forensic triangle. Means motive, opportunity. The logs are hard data. They place specific individuals in specific locations. Palm Beach, Little St. James, New Mexico, on specific dates.
And when you cross-reference those dates with the timelines provided by the victims in their police affidavits?
You find overlaps. You find documented instances of certain associates being physically present at the locations where the abuse was taking place during the time frames the abuse was taking place.
The key audit point here is that authorities had this information. The books, the logs, the computer records, this was all seized and available during that 2006 to 2008 window.
It was. So the prosecution begins with law enforcement already in possession of a map of the network. They had the names. And yet, the NPA was structured to protect that very network. The investigation narrowed to focus only on Epstein, and the NPA then ensured that it could never widen again, at least not criminally. It was a legal dead end.
Now we have to move to evidence block 5 and apply some very strict source discipline. A lot of sensational claims have been made over the years, and it's our job to test them against the actual court records. Let's start with the story of the tapes.
The blackmail tapes. This is the allegation, primarily from a victim named Sarah Ransom, that Epstein had hidden cameras and was recording powerful men she named Donald Trump, Bill Clinton, Richard Branson to use for blackmail.
It's a huge claim. We have a document here, an Epstein file release, specifically document 133216, a summary of legal proceedings from the Giuffre v. Maxwell case. What does this court filing say about the tapes?
This is a perfect example of why you have to read the filings and not just the headlines. This document, which discusses arguments from interveners in the case, directly cites Sarah Ransom's own emails.
Her own emails. And what do they say?
In those emails, Ransom admits she fabricated the story about the tapes. She wrote that she made it all up to try and generate more attention for her case.
She admitted she lied.
Yes. The filing explicitly argues that her own emails reveal Ransom's lack of credibility, regarding the existence of these videos. Now, to be absolutely precise here, this does not invalidate her claims of being a victim of abuse, but on the specific sensational claim of blackmail tapes featuring those presidents, the original source of that claim later retracted it in writing, and that retraction is now part of the court record.
So based on the public record available to us, the existence of these specific tapes is
unproven, and in fact contradicted by the witness's own statements in the legal files. We simply cannot build a factual case on evidence that the source herself has disavowed.
Okay, then we have the defamation lawsuits. Virginia Giuffre versus Alan Dershowitz and Giuffre versus Maxwell.
These civil suits are, in many ways, the real engine of this entire story post-2008. The criminal justice system at both the state and federal level had shut the door. These lawsuits pried it back open.
Because the discovery process in a civil case can unearth documents that were sealed or buried.
That's it. You can subpoena records, depose witnesses under oath. The prosecution begins a second time, really, around 2019, and it's almost entirely because the evidence uncovered in these civil suits from 2015 onward forced the original 2006-2008 evidence back into the public eye. It made the silence of that 2008 deal politically and legally untenable for the Department of Justice.
Which leads us to Evidence Block 6. This is where the discipline is most critical. The intelligence claims, the allegations that this was a Mossad operation, a honey trap.
We have a source document in the file titled Israel Island Child Rape Island.
A very provocative title.
Extremely. But we have to analyze what the document is. This isn't a declassified government memo. It's not a court filing. It appears to be a text that was uploaded to the Internet Archive. It's an article or a manifesto.
And it makes huge claims. It links Epstein to Israeli intelligence's Unit 8200 to Robert Maxwell.
It makes those assertions, yes, but it provides no primary source documentation to prove them within the file set we're auditing. There is no attached government cable, no contract, no financial record.
So we have a record of the claim being made, but we do not have a record of the fact.
That is the crucial distinction for a forensic audit. Based on the available court records and verifiable documents, we have to classify the intelligence operation theory as unproven. We have the NPA. We can hold it in our hands. It's real. We do not have an intelligence contract.
It's important to understand why that theory is so persistent, though. The NPA, that immunity deal we just dissected, it's so abnormal, so inexplicably favorable to the defendant, that people search for an extraordinary explanation. He must have been an asset, the thinking goes, because that's the only way anyone gets a deal that good.
The NPA itself is the best evidence for the intelligence theory, paradoxically. The document is so bizarre that it creates the vacuum that the theory fills. But a vacuum is not proof.
What about the other claims in that text? The mention of Palantir, a tech nexus.
Same standard applies. We've reviewed the Epstein assets files, the estate documents. We looked for financial records, ledger entries, contracts that would link Epstein's finances to these specific tech firms in an operational capacity.
Yeah.
A link isn't there in the documents we have. The files show immense wealth, real estate, a complex web of shell companies, but a specific documented spy tech commercialization partnership. It's not supported by the evidentiary record provided to us.
So we can't say it didn't happen. We can only say the records don't prove it happened.
We have to state the gap. We don't have documentation for that. It's the most honest answer.
So let's synthesize all of this. We've audited the police letters, the weak indictment, the federal MPA, the civil filings. If you were to map the trajectory of how this prosecution began and then immediately failed, what does that path look like?
It's a clear four-step downward cascade of accountability.
Early 2006. The police do their job. They build a solid case with probable cause for multiple felonies.
Mid-2006. The State Attorney Barry Krischer intercepts that case and systematically dismantles it, pushing for misdemeanors.
July 2006. The police chief, Michael Ryder, sees what's happening and makes a desperate move. He invites the FBI in, hoping to save the prosecution.
2007 to 2008. The federal prosecutors take the case and, instead of prosecuting, negotiate a secret deal that grants even broader immunity than the state ever could have, protecting not just Epstein, but his entire network.
It's a complete inversion of how the system is supposed to work.
A total inversion. Normally, in a major criminal case, you have different agencies fighting for the right to prosecute. The FBI wants the collar. The DEA wants it. The local DA wants it. They compete for jurisdiction because a big conviction is good for the agency, it's good for careers.
Here, the record shows the opposite.
The record shows multiple agencies seemingly competing to avoid a public trial. The State Attorney's Office didn't want it. The U.S. Attorney's Office didn't want it. The NPA was the end result of that race to the bottom.
And the accountability gap is crystal clear in the documents. Barry Krischer and the federal prosecutors of that era are identified as the architects of this failure to prosecute.
While Police Chief Michael Ryder is documented as the only institutional figure at the time who actively dissented, his letters are the only proof we have of someone inside the system, in real time, saying, "Stop, this is wrong." He's the only one who put it on letterhead.
So, summarizing the knowns versus the unknowns from this audit.
The police had a felony-level case. The state attorney refused to prosecute it as such. The federal government then granted secret, sweeping immunity to Epstein and all his co-conspirators. Those are documented facts.
Unknown. The specific blackmail material on the alleged tapes, which the primary witness has retracted, and the definitive documentary proof of a link to an intelligence agency, which remains absent from the public record.
When you look at the paper trail, the conclusion is unavoidable.
Yes. The machinery of justice didn't simply jam or break down on its own.
The records show that the machinery of justice didn't jam. It was manually switched off. The switch was thrown first in West Palm Beach, then welded shut by federal prosecutors.
And that weld held for over a decade.
Next time, Alexander Acosta.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.